Under Section 127, Section 126 to apply to interpreters. This section extends the privilege given by Section 126 to interpreters, clerks, or a servant of a lawyers. It extends to communication made to a pleader's clerk the same confidential character that attaches to a communication to a pleader direct under Section 126. Under Section 128, privilege not waived by volunteering evidence. This section 128 of the Evidence Act of 1872 speaks about privilege not waived by volunteering evidence. This section says that if the party making the communication under Section 126 gives evidence at his own instance or otherwise of the matter covered by communication, that does not amount to waiver of a privilege, even if such party calls the lawyer as a witness. It will not amount to a consent to disclosure. But if he questions the lawyer on the very matter of communication, matter will be amount to consent, and by reason of it the lawyer can disclose the communication. Under Section 129, confidential communications. Section 129 of the Indian Evidence Act of 1872 speak about confidential communication with the legal advisor. The bar of Section 126 is partially lifted by Section 129. In Section 126, the protection was given to a legal advisors and advocates that they can't be compelled to disclose information about their client unless the client consents. Here in Section 129 of the Evidence Act, the privilege is given to the client himself. The privilege, however, is subjected to condition, that is, unless the person offer himself as a witness. As soon as the person in question offer himself as a witness, the privilege goes away, but only to the extent of that information which may appear to the court as necessary to understand evidence given by him. The protection to the client is necessary because if there is no protection to the client, then the protection given to the advocate under professional communication will become illusory. Under Section 130, production of title, deeds of a witness, not a party. This section is based on the principle that a great inconvenience and mischief would result to witness if they are compelled to disclose their titles by the production of their title deeds. The object of privilege is that the title may not be disclosed and examined. The section protects the witness who is not a party to the suit in which he is called from producing the title deed of any property, any document in virtue of which he holds any property as a pledgee or a mortgagee, or any document the production of which might tend to criminate him unless he has agreed in writing to produce his title deeds and to raise any objection whatever. It would entirely optional for the witnesses to produce his title deeds and to raise any objection whatever. A books of account cannot be withheld on the ground that it tend to incriminate a witness. The mere circumstances that production of a document may render the witness liable to a civil action does not come within this section. Under Section 131, production of documents or an electronic record which another persons having possession could refuse to produce. Person in possession of a document on behalf of others are generally agents, attorneys, mortgagees, trustees, etc. These sections extend to these persons the same protection which the preceding section provides for a witness who is not a party to a suit. It is not open to litigant to refrain from producing a document which he considers to be irrelevant, and if the opposing litigant is dissatisfied, he may apply for its production and inspection. If he fails to do so, neither he nor the court at his suggestion is entitled to draw any inference as to its content. The use of a compelled word indicates that the person in possession of the document will be allowed to produce document which other persons would be entitled to refuse to produce if such were in their possession. This is in accordance with the English law. It would seem to follow that although a barrister, pleader, attorney or a vakil is forbidden to state the content of any document with which he has become acquainted in the course and for the purpose of his professional employment, he will be permitted to produce the document itself if it happen to be in his possession and he choose to if he choose to do so. This section 131 has been substituted for the purpose of accommodating the electronic records along with the documents. The new section says that no one shall be compelled to produce a document in his possession or electronic record under his control which any other person would be entitled to refuse to produce if they were in his possession or a control unless he consents to their production.